Yeah, boy, yes. And then without any further ado, I am back from the body break. And let us get into this particular reality where we left it on the last time. And I must say, it takes its toll. So when we are here, we are sitting in this true reality. Clause 28D of the housing policy in the Department of Defense provides that members without dependents, divorced, separation, or death of spouse, divorced or separated members whose dependents in terms of a court order have been awarded to the other partner, or a member whose spouse has died and they are therefore to vacate the official quotas within 3 months. Should the member marry again, he or she is free to apply for the same or other quotas. Note that the member cannot, however, automatically remain in the same quotas. Member who, in terms of a court order, are awarded dependents and he or she supports a bona fide household, automatically retains the quotas. Page 161 of the Record of Court takes into account the preamble of the Preventions of Illegal Eviction Act, wherein it says, whereas no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. And whereas no one may be evicted from their homes or have their home demolished without an order of court made after considering all the relevant circumstances. And whereas it is desirable that the law should regulate the eviction of unlawful occupiers from land in a fair manner, while recognizing the right of landowners to apply to a court for an eviction order in appropriate circumstances. And whereas specialized consideration should be given to the rights of the elderly, children, disabled persons, and particular households headed by women, and that it should be recognized that the needs of those groups should be considered. Children. When it comes to children, on the Department of Defense PESOL system, on a dependent profile, Nyeko Mangolele is regarded as my dependent. And effectively, Aluta Songelwa, in terms of this court file by Davis J, says Mr. S.V. Mangolele is granted the rights of access to the minor daughter. The rights of access is this in this particular court order to case number 76579 of 2019. The DOD has committed itself in organizational values that are rooted. And before I get to the rooting of the DOD values, I want us to get to this piece of document here, which delineates all the efforts that were taken to try and then show the court the issues of Nyeko Mangolele and myself and our housing. I will take you directly to this particular issue, which the court ignored. It ignored by fire, by force. See, on 2015, the Minister of Defense tried to take me out of the house, and I appeared there in person. And then the order was made. In this judgment of the eviction. It was in terms of case number 267. And I will take you to a specific utterance by the judge. Bear with me in this regard, I'm just looking for it. And it says here, and again, even if the applicant through its deponent, Captain Said, accepts that the housing policy is not an order, it is a guideline, in his own words, subject to interpretation. And just to make sure that there is no misunderstanding, I have got no difficulty with Captain Said's interpretation of the housing policy. The difficulty that I have is with the status of that policy in this court. If it is not a regulation or an order, then I cannot accept the order issued by Captain Said on 8 October 2012. And the accompanying cancellation of the occupation agreement was legal or valid specifically. I have noted the reference to the respondent illegally moving back into the premises. It is puzzling, I suspect, and I have got no ways of knowing, as this information has not been placed before me, that prior to his divorce and his family relocating, Commander Mangolele was either ordered or instructed to vacate the premises and or vacated it voluntarily. It seems to recall from his papers that he voluntarily relocated. It is not that important, but there is no suggestion that prior to his application, the Defense Force cancelled the occupation agreement, and I find it difficult to understand on what basis it would be held that he is illegally occupying the premises without the proper procedure being followed. The interpretation of this, at least by the writer or the issuer thereof, seems to be that the agreement automatically became void at the time that his family left. That is clearly not so. In terms of any of the documents submitted to me, there is a process to be followed. It also implies that the applicant had the right to enter into separate agreements with other parties in respect of the premises, while that agreement was still in force, which again is difficult to justify. None of it, in any case, is apparent from the occupying agreement or the occupation agreement. To give the order that he gave, and there is no doubt that this letter was an order, it was accepted as such. It was framed in such terms, and it promised certain consequences if it was not complied with. But to give the order that he gave, the captain or the navy could not act arbitrarily. He was bound by the same agreement that the respondent was bound to. In this case, as stated by the applicant's attorney, the applicant relies on Section 3B(3). It does not provide a blanket authority to evict people from naval premises. It provides an authority to evict people from naval premises or to ask them to vacate these premises for a reason prescribed in, as we state at Newsio, the general regulation, the reserve formulation or unit orders. If it is not so prescribed, then there is no basis for such an order and it cannot be given. I suspect that it is more than likely that compliance with the housing policy is indeed a standing or unit order. It would be extremely unwise for the applicant not to have incorporated it somehow, and I find it difficult to accept that it has not been formally acknowledged or proclaimed as an order, but that has never been placed before this court. It has never formed part of the papers. Even the Naval Department or the Defense Force Department that deals with the institution of eviction proceedings, seems to have been placed in a better situation regarding the facts and the documentation than the court has. Those orders were, or the applicant was obliged to provide that authority with the unit orders that has not been complied with. The only assumption is that I can make, in the lack of any evidence to the contrary, is that such an order does not exist. Well, if it does, it certainly does not form part of the record before me. That is not the only difficulty that I have with the applicant's case. The occupation agreement requires that the lessee be given 14 days to rectify a breach. If the applicant relies on that section of the occupation agreement, then they cannot simply use whatever part of the agreement they feel fit. They are bound by the whole agreement. I do understand that it makes no sense to inform a member that you are now contravening a military order. You have 14 days to get married again or conceive more children. I accept the absurdity of that, but even so, that is a procedure prescribed by the applicant. It was the applicant's choice to draft the document. It was the applicant's choice to present that document to the respondent. A further difficulty that I have with the order granted or order given in the 12th October we have dealt now with the fact that it does not seem to be backed by any unit order, standing formation, reserve order or regulation. We have dealt with the fact that no notice was given to rectify the breach. There is no indication that the applicant acted in terms of his own obligation in terms of this agreement, keeping in mind that in terms of paragraph 3B(5) of the applicant was obliged to provide the member with a month's notice after the 14 days, if I understand it correctly. and there has been non-compliance, then the agreement can be cancelled on a month's notice. That was not the order that was given Commander Mangolele. And perhaps if I can get back to what specific order for a moment. Miss, by the way, I see you did index. It is just not everything that has been indexed. The order dated 8th October reads as follows, or the relevant part of this reads as follows. A single member, you are not entitled to family quotas. You are hereby informed that the occupation agreement has been revoked. It is a unilateral cancellation without complying with the Navy's own prescripts to give him the opportunity to rectify the breach. And it then goes to state you are to vacate the quotas with immediate effect. What happened to the month's notice that is required by the Navy itself to be given to the respondent? It seems to me on what has been presented to me that the Navy has not followed its own procedures in order to deal with this matter. The agreement has not been validly cancelled. If I come to that conclusion, there is no need to deal with the other issues that I have set out, specifically the defense raised by the respondent. I am tempted too, and I see I'm going to succumb to temptation because I expect the matter will in all probability be brought back before me, or back before this court. So, good people, here the court holds that the occupation agreement has not been validly cancelled. The status of that occupation agreement still stands even now. It's not validly cancelled. And I want to say it otherwise, but it is like that. I am on the streets unlawfully. The Honorable Samela J neglected the occupational agreement. That was the thing that made me, right there and then, know it to be true that the Honorable Samela J has been bribed. Because the Honorable Samela J doesn't only leave it here. It goes deeper to misrepresent the averments in the policy. And when it does so, it becomes an issue where everything is written to present or to make sure that the parties seeking this relief are favored. It then kills the issue of without fear, favor, or prejudice. And in killing the issue of without fear, favor, and prejudice, just an equitable order cannot be obtained. And I say this in emphasis that judges ought to respect one another and the judgments they have made. I am today simply because people are saying we are respecting a court order by a judge. But such does not come to light with me. The court order of my son in relation to my divorce is ignored. The order of court in relation to my house is ignored. The reality of my son's life, Nyiko Mangolele in particular, is ignored. Nobody wants to know how is Nyiko Mangolele doing, and Nyiko is of age to actually appear before court, where any erudite judge that has listened can summon Nyiko and say, Nyiko Mangolele, is this your father? Do you know this person? Good people, the issue of children is painful. It's painful. And that pain, the upper guardian of the children's rights in the Western Cape does not give a damn about it. In fact, the upper guardian of the children's rights in the Western Cape does everything in his power to make sure that I'm separated from my children. And you want me not to be angry. I'm made to be happy, to say, ooh, happy, happy. And you are busy saluting, hey, boss, Admiral Tlongwani, hey, Shoke, hey, General Rosane Mapwanya, hey, Metandi Mudise, hey, we love you for killing the children and the family of Nyiko Mangolele, Aluta Songelwa, and their father. We salute you for doing that. That is what you mean. Each time you're busy saluting those people, I am not lying to you. There are people who has done this, Malami say. And those people are earning a salary each and every month, while I am not earning any salary. And I'm expected to say, it's fair, it's okay, it is the law, and we shall live and we shall carry on. Good people, things are not like that in the eyes of the law. Things in the eyes of the law are exactly as the law states or wants them to be. Not the way other people want these things to be. And now that you have seen the reality, there are certain procedures such as this one, that must be taken. Checklist for eviction application. Pro forma specifying is application for state quota. See, these are the things that you must check when a person leaves a military house each time. And the issue here is an example of an order was used with permission of the holder of such court order, which is Captain Blake at the time, who had a similar situation, but yet he was granted married quarters because he has dependents. He has a joint custody. I have a joint custody for Nyiko. But that is not entertained. It's as if Nyiko does not exist at all. Right now, it's even worse. Nyiko must not get anything. Aluta must not get anything. Hey, they must just not be with their father because their father wants to make things right. And we want things to be wrong. That is currently what is happening. I avoid the topic of my children because it hurts. It's the most painful. It's the most painful. It's the most painful of all. I grew up without a father. I know how it is like to be without a father. I know. It is not nice to hear other children saying, Daddy, my daddy did this, and then you have nothing to say about your father. It is not nice. Where is your father? He's not there. Where is he? They say he's crazy. Oh, your father is crazy. You are killing my children torturing my children, doing everything that is evil for my children, not even to want to have babies. Good people, what you are doing here is very serious. What is being presented here to you is very serious. And the serious nature of that particular matter is that I know that I have my children, and then I know that I did nothing wrong. Nyiko is my dependent. Yeah, dependent profile. The next dependent that must come in here is Aluta Songelwa. You can list up to 5 defendants. Here's the court order for Aluta Songelwa, granting Sylvester Mangolele access to Aluta Songelwa. Good people, the Department of Defense has committed itself to organizational values that are rooted in individual values, codes of conduct, and unit cohesion. In delivering the defense mission, the DoD continues to pursue and adhere to the following organizational values. Accountability. We shall create a learning organization in which all employees seek and share knowledge and information whilst committing themselves to personal growth. We shall lead by example and influence others to follow these principles. We shall be sensible to the requirements we make of our people and recognize the unique commitments and contributions they make. Consultation rooted and effective and efficient partnership and collaboration. We shall encourage and improve links with other government departments, relevant organs of state, and identified stakeholders. We will strengthen partnership with industry, allies, and the community at large. We shall promote collaboration within the Department of Defense, harmonize activities and systems, and where sensible, share knowledge. We shall consistently uphold a high level of discipline. We shall individually and collectively sustain and safeguard the profile and image of the defense establishment as a disciplined profession. We shall adopt and encourage reasonable working practices. We shall not be deflected by the demands of own vested interest, but those of the DoD. We shall foster fairness and trustworthy in all that we do. We shall not ignore difficult situations. And excellence, we shall build on what we do and actively foster a climate of success. We shall invest in our people and encourage innovation. We shall, where possible, provide appropriate incentive and recognize individuals and team contribution. By the power vested in this rank, I, Lieutenant Commander Sylvester Volane Mangolele, command all South Africans employed in terms of the Constitution and the law, united in their respective constitutional obligations to arrest the decline in critical capabilities through immediate directed interventions so as to rebalance and reorganize our country as a foundation for future growth. I thank you. And in this regard, this was a presentation that was to be presented on 7 December 2021 before the Honorable Thulare AJ. But what really took place in that particular place is this, as follows. And I will not interrupt on it. I will just only let it flow on its own so that you get to understand what truly happened on the 7th of December. And the evidence that you have just heard right now was not presented because a judge came with a preconceived idea And he appeared alone. It was not two judges, it was one judge, which is the first breach of trust culminating from the previous proceedings. Now, you watch this particular reality, which I have recorded in court on that day. As it pleases the court, my lord, the 7th of December has arrived in this particular matter. And this particular matter has long awaited this opportunity of being heard, and the plaintiff is indebted to the court for allowing such to happen. And as guided by statute and guided by the Honorable Sutherland J. in a matter between ALDE and Minister of Home Affairs at paragraph 40, the matter was heard in 2008. He was AJ at the time, my lord. He advised that counsel must research the law and present an honest account of the law. And what I seek to achieve today, your lordship, is commonality, for I stand for the law. I agree with all terms in statute. I defend those particular terms, and we are sitting here as a result of misunderstanding of those particular terms and the application in terms of it. And that's why the leave sought, my lord, is the application in terms of Section 8 of the Constitution, right, with Section 172 of the Constitution. In getting to that point, your lordship, I had difficulties of communicating subtly with the registrar of the court or the manager there too, in relation to having a projector and audio speakers available such that we can have a common point of view and common point of reference in relation to the proceedings and what is presented before court. As the complexity of this particular matter requires a common starting point, which in this term, your lordship, would be a national prayer followed by actually the statute that gathers us here and the subsequent event that follows from that or that flows from that. I would ask, with the leave of the court, for the court to adjourn and ask the registrar to organize a live projector and an extension such that I can connect the laptop and then present this PowerPoint to the court, your worship, my lord.
Let me ask you this. When you woke up,
Yes, ma'am.
and in your mind, what were you coming?
In my mind, my lord, I
What
was...
is it that you saw like
The goal of this particular proceedings, your lordship, is for all people in the Republic of South Africa to live and enjoy freedom in the universal home. But the actual doing in that particular regard is for people to live and enjoy, not people to live and struggle. That would be the beginning point, hence the beginning in prayer. And if your lordship would allow me to express my views in terms of Section 15 of the Constitution, and read with John 5 at verse 4, it tells us that whatever that begins with the Lord overcometh the world. That is why, your lordship, we start any national event with a national prayer. National prayer is very important. And aside from the sufferings and any other issues related to the plaintiff has a duty to the country and its people first, your lordship. That is what needs to be achieved, and then in that, it requires educating one another. And because we have to deal with one another in any event, because such as this particular event, where the trio in this trial is having its own understanding and wanting to reach a common view or a common point. But the common goal of these particular proceedings, your lordship, is for the people of South Africa to live and enjoy freedom.
Do you understand that there is a existing order that says intend not to continue with legal proceedings until and unless it is granted.
That, Your Lordship, I understand fully, and I agree with the terms of statute. Hence, I started to say I defend statute, and we are constituted here in terms of Section 34 of the Constitution to resolve that particular dispute by applying the law to it, because the actual dispute on its own is exactly that particular court order and then its content or its existence relative to statute.
I am asking you this question because I consider the notice of motion.
Yes, ma'am.
And for me, it does not sound in a simple, straightforward application for me to be granted to proceed.
And if I may,
And having listened to your initial comments, and that is why I wanted to establish you woke up this morning and prepare for what is happening. Because for me, from one sitting, it appears to me, unless you convince me otherwise, the object should be now. It's a very simple question. Are you able to satisfy the court that you should be granted and that this is not a piece of property? That's what the act under which you are defined says we should be.
in all respect,
And having listened to you and giving your request for a projector, they don't speak to what appears to be your obligation.
if I may respond, Your Lordship,
Yes, I'm inviting you.
and fully having the founding values of our country in terms of Section 3 of the Constitution as a citizen of this Republic, Your Lordship. His Lordship would understand that in terms of Section 2(1)(b) of the Vexatious Proceedings Act, when you read it in its entirety, to the last bit, it is what His Lordship raised in concern of, is this not an abuse of the process of the court? Is there a prima facie ground for this
Do you
particular?
realize that the court cannot allow you to move into the merits and demerits of your issues with what they have called the defendant in the case until and unless you have been granted? Do you realize?
I would beg leave for indulgence of the court in terms of Section 1995 of the Constitution, and in particular Section 1996 of the Constitution, which obligates the plaintiff not to obey a manifestly illegal order. And the dispute here, Your Lordship, is in relation to the order itself. And that is the dispute that one needs to apply in terms of applying law itself, Your Lordship. Because when one takes into consideration the reality of this particular matter, the formas boni iuris, the smoke of a good right, or graven things which weighing down this particular matter per se, is that the plaintiff was not heard or given an opportunity of being heard before this Malamin said in Lexi, Lo Gai, my Lord. If I am to put it simple, in simple English, Your Lordship, I have paid due respect to the absolute terms that we are here to discuss, and I have no time to waste for the Honorable Court in indulgence in something that does not stand the test of law. That is why, Your Lordship, my duty is to ensure that the defendants and everybody henceforth understand the supremacy of the rule of the law in our country and its meaning. One of our fundamental aspects is that we miss the goal of statute. And when His Lordship looked at the goal of Section 2(1)(b), it imposes a duty on all parties to ascertain whether there is any legal ground or not in whatsoever application or whatsoever merit that is being disputed. And His Lordship, having a library of thought of the Constitution in terms of section 1652, that to be independent and subject himself only to the Constitution and the law, which he must apply impartially, must first hearing, what are you saying? And that should be done, Your Lordship, without fear, favor, or prejudice in any event. I am here to uphold that. I am not against that. There is indeed here a malamanse, wrong in itself, that exists as a result of an unlawful and intentional making of a misrepresentation that causes actual or potential prejudice to the plaintiff, for him to be 38 months without payment of salary. And if His Lordship understands the context of the entire file before him as prayed for in the first paragraph, that met His Lordship's attention days 4 in page 2. As it pleases the court.
My Lord, as we've indicated in the affidavit, there are court orders. The first that he needs to comply with, as Your Lordship has indicated, before he can deal with the merits and demerits of his case. The one being that one of the vexatious order that was granted on the 14th of September 2018. There hasn't been compliance with that order. That order still stands, and the applicant has not complied with its terms, which requires him to make an application to court first and show the court that prima facie he has a legitimate case and that his application is not an abuse of court, and also that he has complied with the court orders that were set out in that order. Further to that was explained to him for the whole of this year. We have been coming to court since December last year. We have been coming to court and preaching the same thing to the applicant, that the only thing you need to do, comply with the vexatious order. And also now, after August, he must also comply with the order of Manu Locus J, which stated that before he can be granted leave to prosecute or institute any action against anyone, he must comply with satisfy the requirements of the vexatious order and also pay the cost of the lawful order. So the reason why the state has not even filed papers dealing with the merits and demerits of the is that the court, the state, I will call them the state, the respondents, they do not know why they are here, because without that compliance, the applicant cannot proceed with whatever action he may want to pursue unless the court is satisfied. Without the state knowing that there is proper compliance with that order, the state can do nothing. Hence, in the note, in the affidavit, we state, okay, this is the position in as far as it relates to this matter. There are certain requirements that the applicant must comply with before he can prosecute or institute proceedings. And he has not done that up to now. And the state cannot even file at this stage because we don't know what is before court. So, my Lord, the long and short of it is that the state has no problem with the applicant instituting applications or proceedings in this court, but he must first comply. And without that compliance, as your Lordship indicated, we cannot even deal with the merits of his case. And it would be very unfair for the state to incur costs and reply to all these allegations that are made in the founding papers when it is not certain whether these proceedings are properly before court. And the only way they can be properly before court is if there is compliance with this order. We know, my Lord, that he did bring an application to sue at some stage in 2019, but it was refused by the judge president. After that, he has not instituted another one where he supplements his paper. What he has done, he has just decided that he's going to institute an action, and he will prosecute it, whether he has complied with with those terms of the discretion order which he must first comply with. So on that basis, my Lord, my submission is that my client's view that this matter is not properly before court. In actual fact, one can even submit that it is indeed a waste of the court time. Because the question is simple. The applicant must just comply with that order and satisfy the court that there is full compliance with that order, and then go to the merits of his case, and then the state will be given an opportunity to file opposing papers dealing with the merits. So, my Lord, my submission is that there is no compliance. As a result of that, there is no proper case before this court.
Should the court be what? And I'm asking you in context what you have observed. Right?
Yes.
In the paper that you find, there are the general conduct of inside and outside. Should the court be concerned about the intellectual context?
My Lord, I would submit that it should be a matter of concern, because explanations has been made to the applicant, but his view, with all due respect, his view, irrespective of what is told to him, his view is that as a soldier, according to him, this order is not, to use his words, this order that requires him to have these conditions to comply with is manifestly unlawful according to him. And it is indeed a serious concern, my Lord, because
is he not understanding or is he refusing to understand?
my Lord,
Or you don't know?
my Lord, based on what you are saying this morning, it could be a mixture of both. He does understand that there is a court order, but he says, according to me, as a soldier who is bound by the law and the Constitution, this order is manifestly unlawful, and as a soldier, I cannot obey it. That has been his, and he will tell me, the court, if I'm wrong, that has been his stance since January or December last year. Because I came to this brief, my Lord, after Christmas, few days after Christmas, when my client received a notice of motion that the matter has been set down for the 5th of January this year. And along my interactions with him, I had the liberty of explaining to him what has happened. He understands and does not understand at the same time, because his view is that this order is manifestly unlawful. Why is it manifestly unlawful? His submission, or what he has told the court, is that that order was granted in my absence. When that order was granted, I knew that the matter was in court on that day. However, I got arrested. He got arrested in Pretoria. So the order was granted in his absence. And my Lord, I explained to him that courts do make default orders when parties are aware of the date of the set down of the proceedings. He says, yes, I was aware of the set down, but I could not be in Cape Town because I got arrested in Pretoria, and I asked to be released so that I attend the court proceedings, but that didn't happen. But be that as it may, my lord, he did make attempts to appeal the order. He went to SCA. We don't know what happened at SCA. That was many years ago. But as far as we know, the order still stands. And I understand your lordship's concern when you explain something to a person and the person don't seem to be on the same page with you. The applicant has his own understanding of what an order is. I even explained to him that, yes, maybe when it comes to military orders, there may be things that are manifestly unlawful. But this one, this is a court order. And a court order is presumed or is always lawful until it is set aside. And this one is not set aside, but that is where he does not agree with the state on this issue that, okay, he said yes, if the order was granted in your absence, hence he was referring your lordship to the act. According to him, a vexatious order can only be made after he has been heard. He says he was not heard that day because he was not here, he was in Pretoria. And I explained to him that courts make default orders on a daily basis when parties do not show up in court. So he does understand that there is a court order in place, but he says to him that court order is not good because he was not present when it was granted. So, my lord, hence I'm saying it could be a mixture of understanding and disobeying at the same time, or there might be a confusion. And it's a serious concern, my lord, because I even explained to him sometime in the course of the year that are you aware that in terms of that vexatious order, if you fail to comply with that order, as I'm advising you to do you know that you are committing an offense which may even warrant the court to commit you to imprisonment? Because if a vexatious order is made and you don't comply with it, you do things contrary to that order, that is viewed in law as being contemptuous. We laughed about it, and I thought the applicant was understanding. But I spoke to him subsequent to that, and it has fixated on his mind that if it was not granted in his presence, he cannot obey it. And it's unfortunate, my lord. It's a very unfortunate situation. But my lord, my client's position is that he must comply with that order. Or if he says the order is wrong, he must have the order set aside. He has attempted to do that. I know that, I'm aware that some of this litigation that he's busy with now, some of the issues that he's raising here, they have been to the Constitutional Court already, and his application at the Constitutional Court was dismissed. Same parties, except the fact that in the Constitutional Court application, there was also joinder of the Chief Justice. Otherwise, it's the same parties and more. So, what we will do, my lord, what is going to happen is that today, if your lordship does not dismiss this application and explain to him what he must do, next week or next year, we will be here again debating the same thing. And I agree with your lordship when he says, when he intimates that this may be a matter of concern on his, as to whether he really understands or not. Because this is not the, even if this application is dismissed, this is not going to be the last time we are here on this issue. And my lord, I can ascertain I can state without fear of contradicting myself that if this court entertains the merits of this case and not make an order that you want, we will be back here, whether there is compliance or not, unless with your Lordship's explanation, you will understand this time. Because the order of Manu Lordwood Jail explains what needs to be done. It was emailed to him. He has possession of it. And it came as a surprise that this matter was set down that week when I was absent without complying even with the Lordwood order, because the Lordwood order adds a fifth ground of compliance. It says, before he institutes or prosecutes any claim, he must also satisfy the court orders of that order. So what we have 5 conditions. If I may highlight them, my Lord, it's a summary of what is contained in paragraph 2 and 3 of the vexatious order, as well as the order of Manuje. It says he must satisfy the court that the proceedings he seeks to institute are not an abuse of process of court, that is 1. 2, that he has a prima facie ground for those proceedings that he wants to institute. 3, he has provided security for costs of the state. 4, he paid the cost orders in respect of the 3 actions that were instituted in 2018. And the 5th one is pay the cost of the Manu Lordwood Jail order. So we've got 3 grounds, five grounds that he must comply with, and none of them has been complied with at this stage. And my Lord, I really feel for the applicant. I feel for him. As a counsel, he's unrepresented. As an officer of this court, I took it upon myself to explain to him what he needs to do. I even recommended to him that perhaps he should seek a free legal advice, either at legal aid or go to the Legal Practice Council and ask for them to appoint pro bono counsel and attorneys for him. Maybe if he hears it from someone sitting on the same side as him, it could be better. Because it could happen that subconsciously he might have said, no, what Titus told me, I must not take his word, because in any event he's representing the parties that I seek an order against. But my Lord, I can assure the court, my advice to him was purely legal and independent. I explained to him, this is what this order says, and this is what this order requires of you before you institute any proceeding. I went even further and said, are you aware that you are risking yourself to some criminal proceedings by continuing with what you are doing? And we laughed about it, saying, I asked him, could you imagine being sent to jail? And when people ask you there, you say, they ask, what is the offense? No, I instituted proceedings in court. We laughed about it, me and him, but it's a reality we are facing, my Lord. My applicant has not brought, my client has not brought an application for contempt yet. But the order and the act are clear, my Lord, that to arrest the situation, the court may have to make a meromoto intervention by firstly, as I submitted and recommended, explaining to him in the form of a court order that are you aware that what you are doing can expose you to some imprisonment for whatever period, my Lord. But to go to prison is a huge risk. No one wishes that for even his worst enemy. So, my Lord, we have an order. We have court orders that are good. One saying you must comply with certain conditions before institute proceedings. Another one saying, as matters stand, unless you come with a better case or you explain yourself better, this court is not granting you leave to institute. That was done in 2019, but that didn't stop the applicant from proceeding with his application. So, my Lord, my submission is that this court must be, before anything happens, requiring my client to file papers, substantive papers, this court must be satisfied that he has leave, or he has a case that warrants him to be granted leave, and advise him accordingly. Otherwise, we will be here next year again. So, my Lord, my submission is that unless this court is satisfied that there is compliance with that order, this application falls to be dismissed with an order explaining, perhaps if it's explained for the third time or the fourth time, it may seem okay. Hence, I submitted that I think it is a mixture of not understanding and willful disobedience, or one of the two. But there is something. My Lord, all those will be my submission in making a case that this application is not properly before court and should be dismissed, and the court shows sanction against the conduct of the applicant. With the warning of the court, maybe the applicant will understand or come to senses that I need to be assisted with this thing. He has the right to institute proceedings, and the only requirement for him is that he must comply with certain conditions, unlike other litigants. Because unfortunately in this case, there is a court order that says, before you institute, due to your history, before you institute, these are the things you must satisfy. Because the state must also be given security for court. None of those requirements are satisfied. And it's on that basis that my client has not filed substantive answering papers, because the case is not properly before court, and to engage with the merits and demerits of the case will be tantamount to endorsing his non-compliance with that law. On that basis, my Lord, my submission is that this application should be dismissed with cost, and an order clarifying the position to be applicable, so that if there is any confusion, it must be issued. Those are my submissions.
If court consent with regard to this what would be your submission to that? That's just a direct question. The Minister of Defense be in a position to assist in relatives
My Lord, my drafting attorney is not here, but I've got an official from the department. Can I take instruction word of that? The instruction I'm getting from the department officials is that he is no longer a member of the defense force because he was dismissed sometime in 2018. Therefore, the department cannot be of any assistance in that regard. However, your Lordship can make an order for the general state institution that deals with matters or that deals with matters. No, my lord. Maybe I didn't understand the question properly. I thought my understanding of the question was whether the department can do something to assist him, not just merely to alert the next of kin. He is in touch with his next of kin himself. He is in touch, as your lordship may have seen in one of the affidavits that he filed. He is very concerned that his grandmother, who's sitting in Victoria, Amaskran, I think, the grandmother is aging, and he says he wants to go and see it, but because he does not earn a salary, he cannot go to Victoria. He told me that when he was coming down here in December last year, when he instituted this case, he had to beg people he know for money. But my lord, we know why he is not earning a salary. According to the Minister of Defense, he is not earning a salary because he is no longer a member. But he is in touch with his family. It's just that he is unable to go there due to financial constraints, and he believes, according to him, despite what the minister says that he has been discharged, he believes that he is still a member. He has not even signed, according to him, and also he states it in his papers, he has not even signed off the pension release thing because he says, according to him, he wants his job back. As you will see in the plethora of prayers he has, there is also a mention of his salary. As he made a submission when he was on his book that he has not been receiving a salary for the past 18 months. So
38.
for the past 38 months. He says he has not been receiving a salary for the past 38 months. But we know, as a matter of fact, that he's not receiving that salary because he was discharged from the defense force. But that has not been accepted by him. He says, yes, I've heard people telling me that I'm discharged. But in as far as I'm concerned, so those are his words, I am still an employee of the defense force. Hence, my lord, what the court intimated as a concern, it is indeed a concern. It is indeed a concern because we have someone who has been formally told that you have been discharged. However, that has not sunk to him. Hence, in one of his prayers, he asked for the payment of his salary. So my lord, it's really a concern. It's really a concern. Applicant knows that he has been told. He has been told that he's no longer a member, but he has not accepted that. Hence, even in these papers, he describes himself as the lieutenant commander of the South African Defence Force in the Navy section. So my lord, I really do not know what sort of order the court may make, to perhaps have him consult with someone who can make a determination whether does he really understand or not. And if he does understand, is he in willful disobedience, or what is the state of his mind? Because, my Lord, after this order, he instituted proceedings in Pretoria High Court. And the department raised this order and said, no, he cannot institute any proceedings in South African court without meeting these requirements. I am advised by my client that those courts, as your Lordship has also done, as he appears in person, they have given him the latitude of hearing him. Because they cannot just say, no, you are not properly before court, leave. They gave him an opportunity, he explained, and then a report or explanation was also received from this court confirming that the order that the department raises as a condition for him to institute or prosecute anything is indeed an order. Hence, the Pretoria High Court sent him to Cape Town and said, go and sort your thing in Cape Town, deal with the order in Cape Town. You cannot institute proceedings in this court in Pretoria because there is a Cape Town court order against you, saying that if you want to institute any proceedings, either in lower court or high court in South Africa, against anyone, not only the state, against anyone, you must satisfy these requirements. So, my Lord, we are in that invidious position where an explanation perhaps should be granted, given to him in the form of a court order. Maybe if there is a fourth explanation, he may come to understand or accept the position as explained to him. It's easy, my Lord. Merely, there is nothing that says he cannot institute proceedings in South Africa. He can institute proceedings. However, he must just comply with that order. It's as easy as that. Comply with the order and proceed with whatever you want to do, and then the merits and demerits thereof will be debated. But as your Lordship indicated, we cannot, this court is not in a position to deal with the demerits or merits of his case until it is satisfied of those 4 or 5 requirements. Unless there is something else, my Lord. Thank you so much for this. Thank you.
As it pleases the court, my Lord, in page 34 in the founding affidavit of this matter, paragraph 5, the plaintiff advanced that the undersigned is a soldier with a clean discipline record since birth. In any event, person says otherwise. In any event, any person says otherwise. Such person must prove to the court the following: account of an offense of the alleged crime or offense DD1 in the military, we call it like that. All people involved before any court of law presiding in a fair trial, including the presiding officer, the prosecution counsel, the defense counsel, the averments advanced by the undersigned in his own defense, the stenographer and the registrar holding the record of court, the judgment, the promulgation certificate or court order.
You can rest assured, Mr. Mangulele, that
I understand that, my Lord. I'm just only putting it to record the founding of this actual argument, so that His Lordship can understand my response to my learned friend.
But let's narrow down.
Okay, in narrowing down this aspect, my Lordship, the applicable. Yes, ma'am.
helps to be a good listener because you can deal with
My apologies, my
I say there is reform in Asian achievement that seeks to profit that one should go into an investigation of your capacity to engage in the issues that are before.
My Lord, I ask you to...
I am holding the faculty, right? And I want you to address me some facts as to why I shouldn't do that.
My Lord,
And if you say yes, it's a cause of concern, what is the way forward?
my Lord, the way forward, simple. The application of law. Simple. Simple. Now, no, there's no thinking or anything. Just apply the law. And in applying the law, firstly, let's start with the provisions of Section 104(9) of the Defense Act. And applying that particular law, Your Lordship, you must apply it without fear, favor, or prejudice. Any person, including myself. It says, any person who falsely represents himself or herself to be a member or an employee of the defense force or department is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. Today, I'm prepared to go to jail if the court finds that I'm not a member of the defense force. As it is unlawfully and intentionally misrepresented on the DOD personal system to stop the plaintiff's salary in terms of Section 105 of the Defense Act, which its goal is conviction to imprisonment for a period of 5 years. In coming to that compliance, the court only needs to ascertain currently, is the plaintiff in jail, yes or no, and make it order. Coming to that, and I follow this logic because this particular instant happened on the 8th of August 2018, before this particular order that we are discussing. So somebody, in his own abuse of power in critical capability, pressed the button, stop salary payment of Mangolele, without hearing Mangolele, without calling him to show cause that he stole a teaspoon or anything, without. That is why in our last encounter, Your Lordship, I have said in syllabus, everything that has happened was that the plaintiff is being denied an opportunity of being heard. Things are happening on the name of the plaintiff without the plaintiff having to say anything about it. Somebody right now, in simple terms, just misrepresented the plaintiff as a female. Everybody wants the plaintiff to comply, to be good. Somebody said I'm a female, and now I'm in compliance. I'm in compliance. As the court or any other person wants the plaintiff to comply to the order. And when the plaintiff takes that action of complying, immediately he derogates from the statutory terms of Section 1996 of the Constitution, read with Section 2E of the Defense Act 42 of 2002 and his Code of Conduct, not to obey a manifestly illegal order. So everybody is pushing the plaintiff to say, comply. And the plaintiff says, am I a female? Just answer that question. Just like the court has to answer statutorily, regardless of whatever amendment that can be advanced in the record of court. Was the plaintiff heard in terms of Section 21B of the Vexatious Proceedings Act, yes or no? Subsequent to that, you will find your answer whether you send the plaintiff to jail for 5 years or you actually apply the statutory terms in terms of Section 21C of the Vexatious Proceedings Act, which only requires any person whom an order against has been granted in terms of Section 21BA or B of the Vexatious Proceedings Act to show good cause. Now, when we speak this English, what is good cause? is it not good cause to say, and I say this, my Lord, with great respect for the dead. I say Nelson Mandela is here. Somebody makes an application, says, no, he's vexatious, he's without legal ground. Nelson Mandela is not here, he's buried. And in showing good cause, acting in terms of section 21C, that's the only thing I can do. Not go there, go there, go there, go there. No, I'm a creature of statute. I act in accordance with the Constitution and the law without fear, favor, or prejudice, and I protect it with my life. The Malamin say in this particular record, Your Lordship, is as aggravating as any evil that any living person can perform. Because what has happened? The plaintiff has never been heard anywhere. And here is the boss. I'm stopping his salary for whatever reasons that may be advanced. And then I'm going to court, bribe. That is the meaning of corruption. And His Lordship, if he understands Section 8 of that particular piece of legislation, it talks directly to the judiciary. It is not there out of wishing that, hey, we think that court cannot say Mangolele is a female, whereas Mangolele actually is a male. It is probable, it is there. That is why that statute exists, where a breach of trust is encountered, as is in this particular case, where people are forcing the plaintiff to comply to be a female, to wear a makeup, to go when he's sitting in the toilet to behave as opposite or contrary to his nature as a natural person. And Section 8.2, Your Lordship, tells His Lordship that he must consider the nature of when applying a Bill of Rights or provision therein, the nature of a person and the juristic nature of that person to the extent. And the extent is such that I cannot obey a manifestly illegal order for somebody saying that I've heard you on the 14th of September. Bring me proof that you have heard me as a judge who, in terms of Article 6 of the Judicial Code of Conduct, is mandated to uphold and apply the law of the land. And as Judge President DeVette had said in page 447, I think, of Law of Freedom, where he said, me as a judge, I'm just only here to apply the land of the law in a case of treason. I'm referring to this case, my Lord, specifically because this action is for crimes against the state in any event. And the state has, instead of respecting, protecting, promoting, and fulfilling the rights of the plaintiff, it does the opposite. And I must agree, knowing very full well that I can have any dispute in terms of Section 34. It is my constitutional right. Am I abusing that when I know every day in any activity that I do, the thing that kills me as a person here is that I know. If I did not know, it would be different. I would be saying, you know, also, and the court had found me guilty, and now I'm actually in prison. So now I'm forced to come.
I have functional intelligence of sociology, and how it is right now.
And if I'm sorry, my Lord, I was just only exercising a fundamental value in terms of Section 6 of the Constitution, my Lord. All 11 languages are allowed. And if I may, if he has any concerns or difficulty in that particular regard, is that it is painful to know. If you did not know that in terms of Section 2(1)(c) of the vexatious proceedings, the court may at any time, and the rules allows the court in terms of Rule 42 to numerate rescindo valida after he sees, hey, this thing, the jurisprudence, and I talk of the jurisprudence, my Lord, with respect to His Lordship's thesis in the subject, because I have gone through that. My Lord, I'm a bookworm. These things to me, I'm just mostly like His Lordship, and I understand that I serve and defend the country and these people. I know that. How do I defend it? As is equally as the Minister of Defense is supposed to do so. When we speak dismissal, let me take, for crying out loud, when we speak relevance, we speak section 210 of the criminal procedures. When we speak right, we speak section 7 of the Constitution. When we speak theft, we speak section 256 of the Criminal Procedure Act. When we speak that, every term that we speak is relevant to statute. When we speak dismissal in the Defense Force, we speak section 591D. And anything that must happen in there, did it happen? Really? Must the plaintiff suffer so hard in confusion of...
You can rest assured I share your concerns, but I'm afraid you moved away from dealing with the specific question. And that is the question
And if I may assist the court in that regard, Your Lordship, is that engagement in this is already sought in a form. As it pleases the court, my lord. Engagement in this sort has been sought before a judicial conduct committee. And that is in relation to this matter. Here it is, it has been filed, it has been accepted, and here are the documents in that particular regard from the Secretary of, it's in this last page, and then it was served already, my lord. It is what I wanted to give his lordship clarity on in relation to this matter. I am not scared talking about the Vexatious Proceedings Act. I am not in doubt, I'm in full support of its terms. My serious concern is what happens in order not to delay any further suffering of the plaintiff. We may engage in whatever thing that comes out of the umbrella in sort of delaying this particular eventuality, which is the supremacy of the Constitution and the rule of law, because Section 2 of the Constitution here, my lord, is directly under threat. Directly, because this particular matter is res publica. Everybody knows about it. Everybody knows that Mangolele is asking us money because everybody is led to believe by a few in critical capabilities that he's convicted to imprisonment not exceeding 5 years in terms of Section 105. That is the point that is stopping his salary. Mangolele has been going to court all the time. And when I say to his lordship, in syllabus, I have not been heard. Every effort is taken by any other judge that I need to deal with in service and defense of my country and its people in accordance with the Constitution and the law. I do not have personal issues with any judicial officer acting in a...
And the battery there ran out. And the battery there ran out. That is what had happened in court, good people. And having that reality that has happened in court, is this reality is misrepresented. The judge has in his findings in this particular reality. At paragraph 11, he says, the plaintiff was a member of You are not a member of the defense force. That is what the judge is holding. He says you are not a member of the defense force. And invariably, that means that this judge agrees that I'm convicted to imprisonment for 5 years. There's no other meaning in relation to this. It simply tells you that the judge believes that since 8 August 2018, I am convicted to imprisonment for 5 years. It means that I went to that court coming from prison. Do you understand? I want you not to get confused. Just like when you believe that this person here is an order, he's declared a vexatious litigant, that simply means when you believe that I was heard or granted an opportunity of being heard on 14 September 2018 by Davis J. It means, Urwena, you don't believe my argument when I say I was not heard or granted an opportunity of being heard. Good people, these people are playing with me and are playing with you and are playing with our country and its freedom. And I want you to understand the actual meaning of the words. Because I'm here as a result of people not understanding the actual meaning of the words. When you say I was a member as a judge, you agree that I am discharged. You agree. So what are we going to be talking about in the next time when you are postponing the matter? What are we going to talk about? Let me tell you what they want to talk about. It says he says the plaintiff was a member of the armed forces of the Republic. Full stop. He held the rank of Lieutenant Major in the Fleet Command of the South African Navy stationed in Simonstown. Full stop. He was charged with 5 offenses relating to what was seen as offensive behavior, 4 of which related to his failure to appear at his place of duty, and 1 to both failure to appear and making a false entry on the day register. It is the events arising out of these developments and their consequence in his life which, in my view, appear to have had an adverse effect on the plaintiff. This judge talks about 5 charges, which we never talked about in this record. We never talked about it. And it's explicitly set forth on the record of court, which he did not want to open the merits of. And I want you to understand, when a judge say on that one, you have to go on that one. And when you simply sit and look at the trail of this thing, this judge has been keeping me away from talking facts to entertaining whatever that he wants to entertain, so that he can say to everybody, no, I have heard him. And I will tell you now what he says about what you just heard. He talks about 5 charges. He does not say that I was not found guilty on all 5 charges. He doesn't say that. And he says that in all other cases that he talks about, when he says, a person was charged for this and then was found not guilty or was found guilty, he says that I know. It's written in his judgments. He doesn't say. He does not even say that these 5 charges were concluded on 15 February 2019, while the salary, the payment, the stopping of the salary was 8 August 2018, before this matter concluded. My salary was stopped while internal disciplinary proceedings before a senior court of a military judge were underway. And they say that is lawful. It's legal. They are trying everything in their power to make sure. People! Minister of Defense, you cannot obey a manifestly illegal order. You uphold the law. Minister of Defense, you are now out of your scope when you don't pay my salary. Each and every single time you don't pay my salary, you are out of the scope of your mandate. You are operating antithetical to the Constitution and the law. Antithetical, it means you are operating opposite. Opposite to the law. That is what you are doing. Pay my salary. Stop confusing poor judges like this one. This one is very confused. And this one, I want him in jail, in a mental institution. I'm not lying to you. It's true. Because he wants me in a mental institution for what you've just seen right now. I will come back to that. So he says, in my view, appeared to have an adverse effect on him. So meaning that if a person is not found guilty, according to this judge, that person has got adverse effect in his life. He's not found guilty. He goes crazy. He does offensive behaviors. You're taking 8th of August, 2018. You are trying to marry it to 15 February 2019. You take that action on the 7th of December 2021. At paragraph 12, and before we go to paragraph 12, good people, there is no rank of Lieutenant Major at Fleet Command of the South African Navy. Minister of Defense, when you agree to that, know it to be true that you are obeying a manifestly illegal order, and you are causing everybody in the defense force to obey a manifestly illegal order, which is contrary to everything that the defense force stands for. We don't obey illegal orders. What kind of a defense are you leading when you are forcing them to obey a manifestly illegal order? To protect the trial. And I say the trial. The tata. The tata. The stupid, foolish people, mumus. You are protecting them. You are paying them a salary. At level 1, we can talk section. We can follow the Constitution. I'm not paying him a salary. I want full dumb people here that do not know anything about the Constitution and the law, and then I will promote them, make them admirals, make them generals, make them everything, as long as they don't know what is the Constitution and the law. Metandi Mudise, review your position as the Minister of Defense. You are embarrassing our land. You are embarrassing our country. You are embarrassing our people. And I will not be scared to tell you that simply because I don't have money. Money is not this country. This country is its people. Batho pele, iseng chelete pele. Batho pele. Chelete, morao, batho pele. Spirit of Ubuntu, not spirit of chelete. Look at my face. And you tell me that you agree when. Right now, you say, Mangolele came from court, 7th December. Hey, I'm not going to pay him. I'm following the order of Thulare AJ. You are making a lieutenant major now in the fleet. Hey, lieutenant major in the fleet command. Ooh, I wish to see the rank insignia of this lieutenant major. Soldiers, There is no rank of lieutenant major. This judge followed hearsay evidence when he was discussing these things with his friends wherever, and then some of them, they told them whatever that they told him, and they told him that I was charged. And then you have heard this judge saying that, no, I have read your papers. You've heard him saying that I have read your papers, meaning that he has read, he has seen the judgment, he has seen the 5 counts, he has seen the not guilty on it, but he misrepresents it in his judgment as an adverse effect on me. And because he's a judge, you are bound to believe him. Had you not heard this video, had you not seen what I have done in court, come to the next paragraph. It says, in my prima facie view, there is a need to ascertain whether the plaintiff can appreciate the nature of the orders granted against him, and consequently the nature of the proceedings before the court, and what he in law can competently place before the court. In law, I cannot say Section 21B of the Vexatious Proceedings Act says I must be heard. And in law, because I was not heard, that section, that order is invalid, unconstitutional, and unlawful. Because you, as a judge, you must obey Article 6 of the Judicial Code of Conduct and apply the law of the land. If the law of the land Act Section 21B of the Vexatious Proceedings Act says the court may, after hearing or giving that person an opportunity of being heard, order that. You want investigation on that. Let's head to this. Can competently place before the court at this point of his intended litigation. In my view, the absence of coherent provision of evidence and prayers for the relief sought, and the general conduct of the plaintiff both inside the courtroom, within the courthouse, and outside, warrants some observation and investigation in his psychological, if not psychiatric position. I have my doubts about the state of his intellectual function and the degradation of his memory. This explains, this may explain his warped papers. So, good people, what you have just seen in court, the way I have been doing things in court, they want me to go to a mental institution for that. They are telling you that my behavior, both inside court and outside court, it warrants some investigation. What are these people saying to you? What are these people doing in my name? What are these people doing in the name of the law? What are these people doing to my children? What are these people doing to my family? Are we really achieving the law here, or are we just trying to frustrate Mangolele, who really cannot be frustrated? Good people, I cannot be frustrated. I'm beyond frustration. And I do not obey a manifestly legal order. That is why I will not obey this order. And for not obeying this particular order, I've set it out clear, straight, that the intellectual functions and the degradation of the memory of Thulare AJ requires investigation. And he must, in terms of Section 27(1)(a)(1) of the Mental Health Care Act of 2002, be evaluated. I am a soldier. All of you who are below the rank of lieutenant commander, I lead you You love me, you don't love me, you've supported me before, you did not support me before. As long as your rank is under the rank of lieutenant commander and you are in the military anywhere in the world, I lead you. I understand that to be true, to a point where I cannot have a judge teaching all millions of you, billions of soldiers under the rank of lieutenant commander to learn that there's a lieutenant major. You only come to the part of major when you have spoken to somebody about this rank of lieutenant commander and its position in the hierarchy of the defense force. And an erudite person will tell you that the rank of lieutenant commander is equivalent to the rank of major in the army. And yes, I understand it to be true that this particular case, it hits people. It's hard on people. There is no judge in the Republic of South Africa who has been removed. There is no judge who has been sent to jail. All of you think that judges are not equal before the law. Hey, judges are people. They are equal before the law. Judges go to the toilet too. Just like you go to the toilet. Judges, they get horny. They do have sex. They do have children. They are people just like you. They drink water. They eat. They cry. They do everything that needs to be done. Now, don't think that judges are not people who don't understand when I say, hey, listen, I have not seen my son for the past 2 years on the papers. Because on record, they don't want me to speak about that. You've seen how this judge leave Advocate Madoda to talk without interfering. You see how often he interferes when I talk. And you see how he leads the conversation to come to say, okay, nah, I don't want to hear about that one now. You are going, no, Emona. I understand human nature, and then my respect to people is misinterpreted to be that I must go for psychological evaluation. And I say this. In Baltimore, I had met the psychologist. She told me straight that, listen, they told me that I must say you are crazy. I must recommend that you are crazy. She told me, the psychologist at Baltimore Medium A, go get that woman. She said, no, Mangolele, you are not crazy. It's just that the things you speak are very big and they are scary. And I said, yes, I know. They are scary. When I talk about removing a judge or sending a judge to jail, it's like, we don't know that one here. Hey. What are you saying? Yo. And it's not that you are crazy when you say that. You are, okay. And I tell you, Mangolele, when these people can take you to a mental institution there, they are going to inject you with things and inject you with things and inject you with things and really make you crazy. That has come in this regard. A judge saying I'm crazy, I must go for mental evaluation and I must come back in 9 March. I tell him about my Christmas and then my children, my family, my grandmother. He said, I'm helping you here. I'm helping you, and everybody else is trying to convince me. No, the judge is helping you for going into a mental thing. This thing is going to be big for you. I say, people, you don't listen to what I've just heard. This guy says I was a member of the defense force. He judged, he concluded without hearing me. And when I say in syllabus, my people, it's continuously. It means that the syllabus, yeah, continuously. I am not heard. This is what I mean. For you to hear me as a judge who understands the judicial code of conduct far much more than I understand it, you will say this person was not heard on 14th September, therefore this order is unlawful by Davis J. This is not a vexatious litigant when we talk law. Because for this man to be a vexatious litigant, he must have been heard or granted an opportunity of being heard on 14 September 2018, not today. What is happening is just people are just building up lies on top of a lie. There's no foundation.
I was not aware of it, so I apologize.
There's no foundation at all. And having no
As it
foundation,
pleases the court, my lord, the 7th of December has arrived
difficulties of
in this particular matter.
having
And
to
this
understand
particular matter has
why
long
people want to say no, this person is wrong. I was wronged. I'm not wrong. When I tell you that I have won in court, it is true. They wanted to tell you that, hey, the court says I'm crazy. You gotta, you know he's crazy. We think, yeah, he's crazy, this one. Because he's been going to court all the time. We don't know what he's talking there. Right now, you know what I was talking in court. You have an account of what had happened in court. You have an account of how eloquent I am in talking. And you know exactly that I am on point. It is what all these judges have been fearing. They don't want to be told that your brother was wrong, another judge was wrong. People, I am the defense force. I have to do these things. I have to say what I say to whoever that I say it to him. Because if I do not say it, who will? Who will say it? Who will tell a judge where to get off if it is not the defense force? Who? You tell me. Who will take a judge and send him to jail if it is not the defense force? In service and defense of the country and its people in accordance with the Constitution and the law. When I talk like that, you are crazy. You can't talk like that. You are a black man in Africa. You can't talk like that. The only ones that talk like that are us who've been bribed by these white people to make sure that you are oppressed. We've heard Mandela saying never, never and never again shall it be that this beautiful land will again experience the oppression of one by another and suffer the indignity of being a skunk of this world. We know. Now you are oppressing me because you don't care about what Mandela said. You don't care about this national flag. You don't care. You act as if you care. You don't. You don't at all. Don't say, aye. We care. Chief Justice Mogoeng does not care about this flag. He cares about the fact that somebody lied about me and said, no, they've listened to me on court record on the 14th of September 2018 in Cape Town. He cares about that. Every other judge cares about that. And when I tell them, hey, I was not heard, that thing actually doesn't exist. Aye, you can't tell us. Aye, you are a vexation. Aye, you can't tell us. You are crazy. Good people, there's no craziness here. There's no craziness here. The only people that are crazy are those judges that believe that I was heard on 14 September 2018. The only crazy thing here are those judges who believe that it is lawful to just stop the salary of a person without calling that person, or giving him an opportunity of being heard, or making anything in terms of a disciplinary hearing. The people that are crazy is those judges that believe that it is correct to stop a salary of a person and then pretend as if you've dismissed that person while internal disciplinary proceedings are underway. Those are the crazy people. Don't look at me and say I'm crazy. Be realistic. Focus and see the truth for yourself. See the truth for yourself. You did not know what happened in court until I've shown you. You would only rely in this thing of saying, this guy says, and the general conduct of the plaintiff both inside the courtroom, within the courthouse and outside, warrants some observation and investigation of his psychological, if not psychiatric position. I have my doubts about the state of his intellectual function and the degradation of his memory. That's a judge saying, I forget. I can't say section, man, I forget. Corey, everything that is precise and proper here is being presented in the opposite. I am proper before the court to say, court, I was not heard on the 14th of September. And I don't know, these people, they just want to drag and drag and drag and drag to a point where I get frustrated. And I'll not get frustrated to tell you that my name is Sylvester. How many people in the whole world, in my whole life, did I tell them that my name is Sylvester? How many? Do you think I have any difficulty of telling you that I was not heard or granted an opportunity of being heard or obligated in terms of Section 21B of the Vexatious Proceedings Act? Do you think I cannot do that? You want to buy time. In buying that time, you are making me eat a pill. Eat it. You are crazy, ne? They say I'm crazy. No. They say I'm crazy. They say I'm crazy. No. They say I'm crazy. Until you start believing that, hey, actually this one is a momo. The judges were correct. People, there's a lot of things here you don't know. Chief Justice, Acting Chief Justice Zondo, call me in. Let's finish this thing. Our country and its people must live and enjoy freedom in the universe, our home. Advocate Madoda Titus, tell the truth, the whole truth, not part of the truth. You are counsel. Present it as it is. Say Mangolele was not heard on 14 September 2018. And with my knowledge as counsel, that order, because he was not heard, it's inconsistent with the terms of Section 21B of the Vexatious Proceedings Act. Say that. Don't lie and say I was arrested on the 14th of September in jail and I could not come to court. No, don't lie. It's an old man. This is not a case of magia, Nini. This is a case of truth. And if you miss truth here, you are selling out your country. Because you fear the white man that was with you, Captain Peterson, in court. The white man who did this. The white man who came with a white version of the national anthem to say, sound the call to stand together, and united we shall stand. Let us live and struggle for freedom in South Africa, our land. That white man. I don't forget what white men did. I respect them. They are people. But I don't forget what they did. I don't. And you as black people, Thulare AJ, you are a black man. You have black children. You expect to have grandchildren. You want them to say to God, let us live and struggle for freedom to please Captain Peters, who was the white man in court. Madod, Titus, you have children. Your children are living and saying, we want to struggle. They are caused by this white man whom you are supporting, instead of telling the simple truth. But in any event, I have no issues with people. I have no issues with people at all. I don't have an issue with Thulare AJ as much as I want him in jail. I don't have an issue with him. I have no personalities with anybody. You either follow the law or you don't follow the law. It's as simple as that. With me in service and defense of my country and its people in accordance with the Constitution and the law. Follow the law. You are fine with me. Don't follow the law. You are not fine with me. And still, even if you are not fine with me, I still have my respect for you. I must respect your human rights. Section 2G of the Defense Act imposes that obligation upon me. And when I say Section 2G of the Defense Act, Thulare AJ will tell you, he can't remember. He does not know. His intellectual and degradation of his memory. When I say Section 1996 of the Constitution, read with Section 2E of the Constitution and the Code of Conduct for Uniform Members, that we don't obey a manifestly illegal order. Thulare AJ, he's crazy. He can't recall. Call the psychiatrist there. Good people, you are killing our country. You must be ashamed of yourselves to be standing in court and promoting criminal activity, corruption, and misconduct. Because in everything that you do, that is exactly what you are doing. I am not scared of anyone. I respect everyone. Don't get confused. Please. Don't get confused. God bless you. Papa. O Teng.